Good morning, everybody. I'm Head of Employment and Immigration at HCR. Part of my job, half of my job title has been ridiculously busy over the last 18 months, the other half less so, for obvious reasons. I'm going to run through employment law as it currently stands. It's not a traditional employment law update in the sense that I've decided that the case law this year has been disappointing. It's quite thin. There's a reason for that. But there's a lot of employment law to talk about. And a lot of it, as you might imagine, is going to be focused on COVID. Can I have the next slide, please? Thanks. So the things I'm going to talk about, obviously COVID. I'm talking about post-COVID. We're not quite there yet, are we? But organizations, businesses, employers of all kinds, from my perspective, are starting to try to act as normally as possible, subject to the constraints of public health and the spread of new variants. But I'm going to talk about post-COVID as part of this morning's catch-up. Brexit, yes, remember that. That's gone quiet. In employment law terms, we read a lot about it in terms of fishing rights, Northern Ireland Protocol and so on. But the splash of employment law reform that was always likely to come after Brexit hasn't happened yet. I think the government's had its hands full with something else over the last 18 months. Case law, the tribunal system and the appeal tribunal system for employment cases pretty much seized up straight away once lockdown started, the first lockdown started. It's eased up and got much better, but certain tribunals have been held up more than others. They've had staff problems, they've had COVID problems, people actually getting the thing and offices closing and having to be quarantined. So for example, the Employment Appeal Tribunal was effectively closed for several months last year, and that has naturally delayed the flow of cases through to be heard by the higher courts. And that's the principal reason why the selection, the normal selection of interesting employment law cases is so thin, and why, in fact, I'm not going to talk to you about any specific cases. Added to that, if I don't stop talking at 9:28, there's going to be the most awful trouble for me. And I'm going to talk about the next 12 months. What's going to happen in the next 12 months? None of us know, but I'm going to have a few guesses, and I'll be interested in talking to any of you later on who are coming to my breakout session, or indeed answering any questions you've got either during the session or just contact me afterwards if anything piques your interest. So next slide, please. Thank you. COVID, obviously we know all about this. Furlough, the scheme came to an end in September. The audit requirements are going to last forever, of course. I'm going to talk about home working. That's a massive issue from an employment lawyer's point of view, and I'm sure will be for the vast majority of people on this session. In some way or other, home working is going to be relevant to you and your organizations. Jab or job, that's a big deal. That's going to be a source of a lot of tribunal cases over the next 12 to 24 months. And then I'm going to talk about contractual flexibility. Sounds boring, but everyone's had a crash course in finding out what their contracts of employment said 18 months ago, and you might want to do something to improve them just in case the thing happens again. Could I have the next slide, please? Okay, so as I say, the furlough scheme closed. It was just a massive state subsidized layoff scheme. And then later on, when we had sort of hybrid working arrangement, it was a state subsidized short-term working scheme. And of all the things that happened during the major lockdowns for the whole of the 18-month period, the furlough scheme, just from a completely non-political point of view, was the most effective thing that the government did to avoid crisis of some kind, because without that scheme in place or something like it, there would have been hundreds and hundreds of thousands of redundancies, no question about it. So whoever thought of it, probably someone buried in the Treasury, I would imagine, civil servant, probably great idea. Well done also for finding the word furlough, seldom used in the English language, was just sitting there waiting to be used for this particular purpose. The furlough scheme, of course, hasn't gone away in the sense that the revenue are going to be looking at how employers have used it, and they'll be doing that for years. There are rumours of huge fraudulent activities going on. I haven't seen any cases like that, but there will be. And you can imagine that that's quite a money-making venture there for the revenue if they only take on a few more people to do that work. Furlough, I'll just mention in passing, because it's a thing of the past pretty much. It was never employment law. You wouldn't have known that if you were looking at the thousands of pages being put out by employment lawyers this time last year, and for most of the summer of last year. It wasn't ever new employment law. It was just a grant application that was quite complicated and related to employment. But employment lawyers who were not, some of them, very busy, especially the barristers amongst the employment law fraternity, that was the only thing they could do, comment on it as if it were new law. It wasn't really new law. There was a lot of gratifyingly old law for someone like me, from the 1980s and 1990s, very familiar concepts. Just the name was new and interesting. Okay, can we move on to the next slide, please? Home working. There's a picture of someone who's happily working at home, or perhaps they've just logged off, you don't know. Home working isn't possible for everyone. It's not possible for every organization. If you're making things in a factory, working at home is not really a practical possibility. I think employment lawyers, because they generally sit in offices, tend to think that it's relevant all over the UK for everybody, and we realise really that it's not. But prior to lockdown, working from home was part of often either an informal arrangement where you were waiting for the washing machine repairman to come and sort something out for you, so you're going to work at home. Or it was something that employers viewed very, very skeptically from a flexible working point of view. So someone might ask for flexible working, not change their hours, but just ask to work from home occasionally for all sorts of reasons. Can be any reason these days. And I think employers, in my experience, were reluctant to agree to home working because there's always the idea that if you can't see your employees, they can't be working. And what the last 18 months has been, if nothing else, is a massive forced experiment of home working for a lot of employers. And the conclusions are mixed. Sometimes it's fantastic for the employees and for the organizations. Some organizations have embraced the idea of having people working from home. I mean, really embraced it, and are thinking of closing offices, making their office space much more restricted, on the assumption, I think, that everything can carry on beautifully if everyone carries on working at home, and that employees will like that. But that is not necessarily the case. There are many employees who, for all sorts of reasons, are not comfortable working at home, haven't got the resources, don't have a nice working space that they don't have to share with 4 children running around, a dog, 2 cats, and someone else who's trying to work at home at the same time, let alone school-aged children being sent home because of COVID outbreaks or the risk of COVID outbreaks. So not every employee is going to be happy with the idea of working at home, but many are. So mixed outcomes there. And also, I should say that managing through a crisis, being able to have people working at home and having sufficiently good computer systems to allow them to work successfully from home can work for lots of employers for a limited time, and money can be made, and it can work out like that very nicely. But is it always the best? Isn't it always just a bit second best for a lot of employers? So I think employers who've got excited about the idea of having people working from their own paid for workspace at home, they may be missing something about the benefits of people coming in and mixing and seeing each other. And I'll come back to that when we're talking about employees and what their plans are for the next 12 months. Home working, obvious point, check the contract of employment. Not vital 18 months ago because everyone was racing to the door to get away from their colleagues and their bosses so they didn't catch anything. So no one was looking particularly hard at contracts of employment at that stage. Now that employers may want to rely on or wish employees to stay at home, they ought to look at the contract to see if that's actually provided for. Your workplace is a contractual term. Okay, so don't forget to look at that. Another thing that's worth mentioning, and I'll probably mention it later on, I'm sure I do, but I'll say it now in case I don't get time to later on. As I say, 18 months ago, everyone rushing for the door, no one was particularly worrying about whether there was a short-time work layoff clause, a clause that allowed you to send someone home for no money or less money. Next time it happens, everyone will be looking that much harder. Employee preferences, getting people back into work is going to be much more complicated than sending them home at the beginning of lockdown. So my big tip for employers in general is to find out what the employees want to happen. Just ask, find out, because they may solve a lot of your problems for you, both in terms of having a safe working environment in the still ongoing COVID situation, but also for an employer's future plans. It always pays to find out what individual employees are interested in doing and what their particular problems are, because that will avert 90% of employment law issues. Same in most cases. Could you give me the next slide, please? Jab or job, this is a big deal now in some sectors. Care homes already covered by a rule that says, subject to certain exemptions, if you aren't jabbed, double jabbed, you can't go into a care home. And that's whether as you're working anyway, as an employee, but particularly for all you commercial types. I see that lots of you signed up for the commercial session, so you're very interested in commercial contracts. If you're supplying a service to a care home, for example, you'll be very interested in knowing what happens if one of your employees isn't double jabbed, can't go onto the premises of a care home. What are the commercial issues there, let alone the employment law issues? So, big deal, both from employment lawyers' point of view, but also for a commercial law point of view as well. The NHS is going to be covered. Few people on this call are going to be from the NHS. I'll jump on onto the next bullet point. Blanket rules for having people jab before they can do their work. Blanket rules are always the road destined towards indirect discrimination of some kind. You may have to have a blanket rule sometimes, but often you don't. So employers shouldn't lazily assume that they have to oblige their employees to be double jabbed in order for them to do their job, because it may not be true. So in any situation, you've got to look at what your obligations are to your other employees, health and safety, to your commercial partners, and to other third parties. But do not assume that you've got the right to have a blanket policy. You're just getting yourself into inevitable problems with individuals who, for whatever reason, aren't happy with that decision. And I've touched already on the commercial law aspect of this. If requirements to be double jabbed become more prevalent, then it's going to crash into commercial law situations just as much as it will employment law situations. Could I have the next slide, please? I mentioned earlier on, I was worried in case I wouldn't say it now. If we have something similar again, even if we have an extended extra lockdown, whatever it's called, Plan B, Plan Z, new variant, whatever it is, when it happens again, the employees will be looking much more closely at whether what you're asking them to do is actually in their contract of employment. I think, in fairness, in relation to all sorts of things that come out of COVID, most of my clients, either because they're clever anyway, have thought about these things well in advance. So when we were talking about possible redundancies at the end of the furlough scheme, I haven't seen a massive wave of redundancies yet. Maybe the claims will all wash in later on. With terms and conditions, it may be that employers in general have looked at the flexibility that they have in the contract of employment and either sorted it out straight away in March or April last year, first lockdown, or they've done it since. But look at your contract of employment to see whether you are able contractually to send people home for no money or less money, because it was always a requirement of the furlough scheme that there was written consent. Something in a contract of employment is written consent. So in case we get into the same situation again, and COVID rears its ugly head, and there's a lockdown, look at your contracts of employment now sorted out. I've mentioned working at home, place of work clause. You can't rely on a clause that says you'll work in our office and your premises, but occasionally you have to work somewhere else. If you're telling someone they're going to work at home all the time, that's a different deal. And different ways of doing the job, that's partly the same issue of working at home, working in a different way, using apps like this, platforms like this to have meetings. You've got to make sure that your employees have bought into all those things, that they're required to do them. I may as well throw in here using Teams, Zoom, whatever platform you're using to deal with difficult things like grievance meetings, disciplinary meetings. Can we have the next slide, please? Brexit, right. I have no idea at what point the government might become interested in employment law issues that arise out of Brexit. Immigration laws have already changed, you'll all be aware of that. Immigration is a hugely political topic and in the news all the time. So you can see what's going on with immigration rules. Normal processes of flying people in for particular types of work, skilled work situations, they continue, and my team still deals with those applications for skilled worker visas and other visas. So, you know, that has carried on. Obviously, the number of people flying in and out of the UK has gone down significantly, and so immigration law will come back, and those laws will be more relevant. But obviously, since Brexit, about 450 million people can no longer just wander into the UK and work under an EU treaty, just at the moment. The UK government hasn't really had a chance to set about reforming, in inverted commas, employment law following Brexit. The EU and the treaties surrounding the EU were the thing that bound a lot of our employment law together. Not everything. Employment law was homegrown, but anything to do with equalities, very much grounded in EU law. We know from the way the government approached the Northern Ireland situation that treaties can be made and then they can be unmade. They can be renegotiated. So even though the government may start on the basis that they're going to stay in broad alignment with the EU employment law and social economic law, if you like, approaches, that doesn't mean to say that they're not going to change their mind. And employment law is inherently political. And one way of any government, the current government, particularly at the moment, which is struggling somewhat, one way for it to get its support from the last election back on side is to sell the idea of a bonfire of red tape. So I expect that round at any moment, but not at the moment because they're busy doing other things. But things that might crop up there, TUPE, collective consultation for redundancy, for example, and also for transfers, holiday pay, all those messy, difficult things, horrible employment law that implicate dealing with, they can be sold to employers and they can be sold to voters, oddly, as being tremendous things for the government to do, even though on the face of it, if you're one of those individual voters, you may lose out by these reforms, the government would be able to sell that as part of the overall Brexit benefit, if you like. So again, without wishing to be political, I see that process being accelerated and there being a lot of employment around the corner that will liberalise, to use another loaded term, employment law and employment rights that may end up looking to certain media. Okay, so that's code for things that are going to change quite soon if the government isn't occupied with COVID. Next slide, please. This is the point at which I mentioned that I haven't talked about the case law. And before I slide, the cases that are going to come up in the coming years are going to, they're not going to be about, the interesting ones aren't going to be about redundancy, because redundancy and redundancy selection is pretty well set. Something I always say to any employer or in-house lawyer who's passing is that if they've had people on furlough and they're still on furlough or were still on furlough and they've selected them for redundancy just for that reason, I'll see them in the tribunal at some stage in one way or another, because that wasn't a good way of doing things. It's too late to advise anyone about that now. That would have happened already. I think that the big cases are going to be about jab or job, conflict of discrimination laws, cases about religion and philosophical belief, questions for employment tribunals about whether certain philosophical beliefs, like being an anti-vaxxer or having a particular medical view that isn't crazily anti-vax, but is on the respectable end of that spectrum, if you like, whether those views are respectable in a civilized society, because that's effectively the determination the employment tribunal is asked to make in those cases, to see whether they can be protected. So there's going to be a lot of cases about that, because there's going to be a lot of angry people who are going to lose their jobs or or for whatever reason, because they won't be jabbed. So expect that. That's going to be a nice work stream for me over the next couple of years. Fire and rehire. There's some ACAS guidance that's just come out. Go to their website, look for fire, rehire. To an old employment lawyer like me, that annoys the hell out of me. Employers have been dismissing and re-engaging employees since contracts of employment were invented. It's not new law, it's old law, but read the guidance. It'll teach you how to be nice to your employees. I'm always in favour of that, but it's not new law. Jab-related problems I've mentioned. Sectors in crisis, I've mentioned a few there. We will see this. We see it because we see it in the news. We see it because we can't get into our favourite restaurant or cafe because they can't find any employees, and any number of reasons are given. We see it in supermarkets because the shelves are a bit empty. Some sectors are just in crisis in terms of recruitment and so on. And there's no reason why that is going to stop happening. The Great Resignation is something that's been mentioned. There are said to be a very large percentage of employees in the UK who are just waiting to give their notice in. They're either fed up with what's happened over the last year and a half, or they've loved the last year and a half and they want to do a bit more of it without the employer hanging around their neck. Or they've realised that they can do their job for more money without moving their desk, but be said to be working in London or Bristol or Birmingham or Leeds and earn more money. So watch out for your employees just going wandering off and working somewhere else if they've been working at home, because they can do that for anybody. That's a thing that employers have learned, that they can hire all over the country now to do jobs. You don't have to be local anymore. So watch out for that. My tip there is to look at your employee benefits and show a bit of love to your employees, because otherwise they'll just be waving goodbye during the next 12 months. I think I'm going to stop there. I'm on time. Got a gold star. If you've got any questions at all for me, either raised by the last 20 minutes or so, raise them in the chat or email me afterwards. You can always get a hold of me. Happy to answer any questions without the meter running, within reason. Terms and conditions apply. But thank you very much for listening.